Okay, so in this first video we're going to be looking at copyright in music and copyright in the music industry in general, but specifically copyright that relates to songs and music. So first of all, what is copyright? Copyright's one of the weird things that most people probably know about, they probably heard of it, but a lot of people don't really understand what exactly it is and what it does and what it doesn't do. So basically, copyright is a property right. So just like a car or a house, or a laptop or a phone or anything else that you can own, any property that you can own, it's essentially the same kind of thing. It's a property right. The only difference is that it's an intangible property rather than a tangible property. So you can't actually physically touch it, you can't physically see it, but it's property and it can be bought and sold in exactly the same way. It is time limited, which most property isn't. You couldn't leave it to your daughter as inheritance, or your son as inheritance, or your nieces and nephews, in the same way that you can leave property, or your car, or a phone. You can obviously leave it in a will, you can transfer it to anybody in the same way, but it will expire 70 years after your death. So it's slightly different than regular property. But what it does during that time, it gives the owner exclusive rights to do things with that material, things that other people are not allowed to do, those that don't hold the copyright. You can do that freely. You can also assign it to different people. You can license it out. You can sell certain sections. You can give it all away. But it gives you the right to control what happens to that work, and you can also use it to provide a way of making money. That's kind of important. Most of the time in music, you've got to make some money. So copyright gives you that kind of protection that you can make money, or at least it does in theory. So when you're thinking about the copyright that exists in a song, and by that I mean a recorded track, you've got to break it down into three elements. You've got the lyrics, the music, and then the sound recording. They all make up separate copyrights in their own right. So they're all separate entities, and they can all be bought and sold, and they can all be owned by different people and licensed out to different areas and different things like that. So just remember that there's not just one copyright. So if you take, say, Single Ladies by Beyonce, no one person or no one entity owns one copyright in that. There's copyright in the music to it, there's copyright in the lyrics, and then there's copyright in the recording of it itself, the master recording of it itself. And by music, I mean everything apart from the lyrics. So the composition of the song. And all of this kind of comes under the Copyright Design and Patents Act. Everything to do with copyright, or almost everything to do with copyright, all comes under this one act. And it sets out that there are three different major types of copyright. The first is original, literary, dramatic, musical or artistic works, and this is the thing we're probably going to focus on the most, because this is where the creative kind of stuff is held. This kind of has to be original, which we'll go into in a little bit more detail in a minute. But this is this is where the lyrics are, and this is where the music is. The literary works is the lyrics, and the musical work is obviously the music. And then again, on top of that, you've got the sound recording, which makes up the recording, the master of the song itself. So how do you actually get copyright? This is one of them things that, again, this is where a lot of confusion comes in. People tend to overcomplicate it. There are even companies that you can pay to copyright songs or lyrics or a recording, whatever it is. There's companies that charge you a fee to protect your work, and it's not necessary at all. It's kind of split into two sections here when we're talking about music. You've got the original work and the derivative work. And the derivative work is the recording of the sound itself, so the recording of the material. It's a derivative because it's not original in its own right. It's just a reproduction, in a sense, of the work, of the music. And with the original work, the music and the lyrics, the only kind of requirement that we've got there is that you have to create something original. and the threshold for that is pretty low actually. We use what's called the sweat of the brow test in the UK, and that basically just means you have to give some kind of effort, some kind of talent or skill to create this work. You have to have done something to achieve what you've created, and then you have to write it down, or it has to be recorded. It has to be fixed. It can't just be an idea. You can't copyright an idea. There's no copyright in an idea. It's all the expression of that idea. So once you've got a song, if you've written a couple of lyrics on a page, boom, you have copyright. It's as simple as that. As soon as you write the music down, you've got copyright there straight away. Done. Nothing else to it. Automatically created. There are no formalities. There's no forms to fill in or anything like that. And there really is no need to send it to yourself in the post either. A lot of people seem to think that that's a good way of securing copyright. You can get copyright. You can save spending money on a company that are going to set it all up for you when you can just send it to yourself in the post. Okay, that makes perfect sense, but you don't have to at all. It's already there. It's done. You can send it in the post to yourself, but all that really does is prove your ownership of it, or prove your possession of that material at that time. It's going to be date stamped and sealed and all that kind of stuff, so you can prove that you had that in your possession. If in 2 years' time someone comes and says, wait, no, that's my copyright, you can go, well, no, it's not. Here's my proof. But it doesn't actually set up the copyright itself. Copyright is automatically created when you create the work, or whoever it is that creates it. As long as it meets the requirements of being original, and it's kind of recorded in some way, written down, then it's there straight away. There's nothing more to it. As I mentioned earlier, it doesn't last forever. In the music and the lyrics, the musical works and the literary works, it lasts for 70 years after the author's death. So if you write a song today, if you write the lyrics down today, as soon as you die, it gets to the end of that calendar year, and then it's 70 years from that point. Pretty simple, really. And with the sound recording, so the masters in the song, if you record a song and someone owns the masters, then that lasts for 70 years. Full stop. There's not a lot else really to say about that, other than it used to be 50 years until they extended it in 2013. It was extended on the basis, from a lot of pressure from the music industry, because obviously 50 years ago there was a lot of good music, namely the Beatles, out and about, and if the law hadn't extended that kind of period from 50 to 70 years, then quite a few of the Beatles singles would now be in the public domain, which a lot of people aren't really that comfortable with yet, and probably for good reason. But while we're on that subject, public domain is probably worth talking about briefly just now, because there's also a lot of misconceptions about that. People seem to think if you pick something up on Google or Instagram or Facebook or Twitter or something like that, then you've got it from the public domain. I got this image from Google Images, so therefore it's in the public domain. But it's not. That's not what the public domain is. Public domain just means that the copyright has expired on it. So it's pretty old, basically. Like a lot of old classic books and things like that, they go into the public domain, so you can download them for free on Amazon and stuff like that. But the public domain is not just putting things online. Just as though if you put your a track or a demo or something onto SoundCloud, that's not putting it in the public domain. You're just exercising the right to make a copy of it, or to perform it publicly, which is one of the rights that you get as part of copyright, which we're going to look at now. So the exclusive rights that you get under copyright are making copies, issuing copies to the public, renting and lending to the public, showing, performing and playing, communicating the work to the public, and making an adaptation. Now, I think they're all pretty straightforward. Making copies is basically anything from, if you produce a master of a track, you can then make physical CD copies of that for either to make money or otherwise. And I think also downloading MP3s, it comes under that category as well. And interestingly, when you actually physically go into the studio to record a song, then you're also making a copy, because you're making a copy of the other two elements of the song. You're making a copy of the lyrics, and you're making a copy of the music. So straight away, to get the recording of the song, you're already exploiting one of the main parts of copyright. So you can't just go and copy somebody else's song, obviously. You've got to have permission to do that, to record it, and obviously to distribute it and make money and all that kind of stuff. Showing, performing, and playing, that kind of focuses mostly on the performance rights. So we're talking here things like actually performing the song live. So we're not talking about the mechanical rights here, the rights in the recording. We're talking about the music and the lyrics. So that's just literally playing the song live. So if you got a song, you can control who plays it live, when they play it live, that kind of shit. And communicating the work to the public. Yeah, communicating the work to the public it's kind of similar to making copies, but slight distinction, and it's getting a little bit weird with the whole new streaming stuff. But communicating the work to the public is basically when you've got the recording and you put it on the radio or on TV or on YouTube, and on Spotify. And there's a lot of kind of contracts, old recording contracts before the internet age, which are kind of arguing this out at the moment. Is it communicating the work to the public, or is it making a copy when it gets streamed? And kind of general way of thinking is it's communicating the work to the public. It's like a radio station, so all that kind of stuff kind of comes under there. And obviously you can use these rights. You can assign them out to different people, depending on who's best to control them. Because if you're a songwriter, then it's no good just keeping the copyright to yourself. Most of the time you want to put it out to a publisher or something like that. So commercially, under a standard contract, then music and lyrics are generally assigned for a period of time to a music publisher, which it differs a little bit from the sound recordings. If you're a solo singer or something like that, and you you sign a recording contract, you go into the studio, and the copyright in those recordings are generally assigned to the music company, the record company, permanently, or whoever pays for the recording, whether it's a publishing deal like 19 Management, 19 Recordings, or whether it's directly with the label. And then these companies, your publishers and the recording companies, they generally grant licenses out to various different bodies like PPL and those kind of things. I'm probably going to talk about that in a little bit more detail in another video. Probably the next video, all the different bodies within the music industry and who gets paid what, when and why and how. But for this video, I think that's about it. Obviously, if somebody does use your work without your permission, then you can sue them for damages, and that's basically the whole point of copyright. If you have something, if you own it, then and you're not getting paid for it, then you can sue somebody and get some money back, or at least in theory, obviously. With the whole downloading thing and torrents and everything like that, people are downloading music illegally all over the place, and all of that is protected by copyright. So essentially, can everybody get sued for damages? Well, yeah, but it's kind of impossible. So obviously we need to figure out a little bit of a way of getting around that and sorting that out. But yeah, that's the overall kind of outline of copyright in music. There's not much more to it than that at this kind of stage. If you do have any questions or anything like that, just pop them in the comments below. Or send me a message somehow. I guess you can do that. This is my first video, so I'm a little bit all over the place with it, but hopefully it'll get a little bit better soon. If you did find it useful, please like and subscribe and share it with anybody that you think might be interested or it might help out. And yeah, keep looking. I'm going to make some more videos, probably get a little bit more interesting, look at the different bodies as I just said, also look at like performance rights and mechanical rights and all that kind of stuff in later videos. So yeah, please subscribe and I'll see you soon.